Welcome to our video series, Industry Viewpoints, brought to you by the American Bankruptcy Institute. I am Bill Rochelle, ABI's Editor-at-Large. Each segment will feature an expert providing views on a current state of affairs in a particular industry, with an emphasis on what lies ahead. My guest on this edition is Robert Eisenbach, counsel in the San Francisco office of Cooley LLP. Bob was an undergrad at LSU, having grown up in Louisiana, but he went off to law school at UVA, and then he returned to Louisiana to clerk for the Fifth Circuit. But being an IP lawyer, Bob ends up, of course, in San Francisco, which is the hub of the IP world. Here at ABI's annual spring meeting in Washington, D.C., Bob was on an intellectual property panel. And that's what we're going to be talking about with him for the next few minutes, is intellectual property. Now, Bob, you understand all of this stuff vastly more than anybody else on earth, probably, because IP is so complex, especially, well, it's complex no matter what, but in bankruptcy it's just maddening. And a maddening question came to the Supreme Court 2 or 3 years ago in the Tempnology case, which was really groundbreaking. It taught everybody that whatever they thought about bankruptcy law and technology was really not true. So, refresh our recollections, Bob. What exactly did Tempnology teach us?
Yeah. So the Supreme Court was faced with a question that, when you think about it, it's remarkable hadn't been clearly answered, but it was, what's the impact of rejection of an executory contract?
But the code says it's different, isn't it, for different kinds of products?
Well, not exactly. So there's some differences. So the context here, Bill, was that the Supreme Court was faced with a trademark license. So a license is an executory contract almost all of the time because there's material performance yet due on both sides. And in this Tempnology case, the trademark licensee found its licensor, Tempnology, going into bankruptcy and rejecting the trademark license and taking the position that that meant that the licensee no longer had rights to continue to use the trademark.
Okay, well, now didn't the statute give us a very clear answer?
So the statute...
And trademarks are left out, so you're out in the cold. Isn't that right?
Well, yes, the statute gave us an answer. So the statute that we're talking about is in part Section 365N of the Bankruptcy Code, which provides for protections for licensees in the event, in particular, in the event that their license is rejected.
Who's protected? Under that section?
So that licensees of, quote, intellectual property, end quote, because I'm quoting from that Bankruptcy Code section. So you go to the definition section of the Bankruptcy Code and you find, which is Section 101, and you find subsection 35A, and it lists a series of things that are intellectual property means.
Okay, what's intellectual property? What's protected?
So patents, patent applications, trade secrets, copyrights.
Okay, so that's the answer.
Yes, but not trademarks.
Trademarks is not there, therefore there's no bankruptcy protection for trademarks. Isn't that perfectly clear under this plain meaning, as Justice Scalia would say?
Well, what's interesting is, knowing that that would be the answer under 365N because of that definition section, 10135A, not including trademarks, the licensee in Tempnology made a different argument, which is rejection doesn't mean I lose my rights. And what the Supreme Court was faced with...
But everybody had been saying you do.
Yes, for many, many years, until the Seventh Circuit stepped in and issued a decision that created a circuit split, principally with the Fourth Circuit in the Lubrizol decision that actually led to the enactment of Section 365N in the first place, back in 1985. But in the more recent decision out of the Seventh Circuit, creating this circuit split, the court said, no, that's not right. And it led to the Supreme Court answering the question, what does rejection mean? What is the
Yeah,
consequences
mean?
of rejection? And the answer that the Supreme Court said quite clearly was rejection means breach. And it means breach by, of course, the debtor who's rejected the contract and is not going to have the affirmative obligation to perform under that contract. But since what the Supreme Court went further to say was, since rejection means breach, and it doesn't mean termination, and the rights that were already granted, in this case, the rights to use the trademarks, could not be taken away from the licensee because it didn't breach, the debtor breached by rejecting it.
Okay, so I guess it's kind of like this. Suppose that I own trucks.
Okay.
I lease you a truck. You're the lessee, I'm the lessor. I go bankrupt. I reject the lease. I guess it's pretty clear that in bankruptcy, I don't get the truck back.
Yes, actually the Supreme Court didn't use a truck example, but used a copier example, like an office copier, when people were back in, this came out in 2019 before the pandemic, so people were thinking about offices and office copiers, and said just because you go bankrupt and reject the lease doesn't mean you get the copier back. It's sitting in the lessee's office, and they need the copier as long as they keep paying the cost. They didn't breach. The debtor breached. So that's really what the Supreme Court did, giving licensees of trademarks now rights that for many years it appeared that they did not have, and often trademark licensees before this decision were left without continuing rights to their trademark license.
Yeah, I can imagine. Was horrendous in some situations.
Yeah.
You could have put millions of dollars into developing the use of a trademark, and then
Right.
it's gone.
Right.
It's gone. It would be like blackmail.
Yes.
You'd have to pay the debtor a lot of money to pay the debtor again to use something you thought you already had.
Exactly. Exactly.
Well, I guess all this is due to the fact that intellectual property is such a strange animal. It's not really a sale. It's so amorphous.
Yes.
That's why I'm glad, Bob, that you work in this area and I don't, because it's just way too difficult. So let's now focus again on the Tempnology situation. So what does Tempnology now mean for the licensee where the licensor has gone bust?
Yes. So it's direct application, and I think the thing where it really matters is the case that came before the Supreme Court, a trademark license. But there are some interesting questions about the consequences of that decision. Would it affect something else?
Oh, such as?
Well, so remember that section 10135A defines intellectual property for purposes of the protections given under section 365N. And those protections are important. They allow the licensee for covered IP to elect to retain their rights to the intellectual property. If there are royalties that are owed, they have to keep paying the royalties, but fundamentally they are able to keep the license to the intellectual property that was previously granted to them before the bankruptcy. So, but it doesn't cover everything. Remember, I talked about patents, but what it really says, what that code section really says, are patents protected under Title 35. Or inventions, and so forth, under Title 35. Well, Title 35, you can't get a patent for everything. So one area that practitioners have focused on is, well, what about foreign patents?
Yeah. What about it? What if you're a licensee of a foreign patent?
Right. Does Section 365N protect you? It's not entirely clear. I think a good argument is that if that patent that you got, issued by, say, the European Patent Office, is the same kind of patent you could have gotten or did get, or from the U.S. and the U.S. Patent and Trademark Office, then probably is protected. But we don't have any case law answering that question.
Well, let me ask you this: do we really even need that subsection anymore?
Well, the Supreme Court in Tempnology, it's a good question, right? Because, well, Tempnology is saying rejection just means breach, so can't everybody be essentially like that trademark licensee in the Tempnology case? And the Supreme Court didn't, I would say what the Supreme Court fundamentally was trying to say was that's a specialized exception, it's still there, and appeared to imply that if it applies to you, you follow Section 365N. Here it didn't apply to the trademark license, so the trademark licensee had to go beyond that.
Well, yeah, now let me ask you about that. Maybe now, years later, after trademarks were left out of 365N, are they really better off? Let me ask you this question. Licensor of trademark goes bankrupt. Licensee wants to keep it and use it. Mm-hmm. It's not covered by 365N, but it's a breach. It's been rejected.
Yep.
Breach, no doubt about it.
Yep.
Does the licensee have to continue paying royalties?
I think that the answer is most likely yes, because the Supreme Court, the decision seemed to imply that if the licensee didn't perform its end of the bargain, then it be in breach. And that could be its own cause for perhaps leading to the termination.
Oh, wow.
So it was not expressly answered. I mean, the Supreme Court didn't say, in order for this to happen, you must do the following. But it seemed to be the implication, I think, from that decision. But that's another area of argument. I think the other thing to think about is, okay, well, are there other types of IP, or at least things that people think are IP, that might be get some protection in light of the Tempnology decision?
Yeah, tell us about that. What else?
So one area that comes to mind are there are a lot of data set licenses out there where one company has compiled or has certain data, and another company would like to use it for one purpose or another, or maybe even an ongoing series of purposes. Well, if it's not protected under the copyright law or the patent law, sometimes it might be, but if it's not, then it's kind of like trademarks. It's not mentioned in the list of defined covered intellectual property under the Bankruptcy Code, or at least there's an argument that it's not. And if so, maybe then the Tempnology decision gives some extra protection for that licensee. So there could be some other applications. The decision's only a few years old, haven't had a lot of cause to have cases like that, but it could be interesting to see as it develops.
Well, you know, so much in our economy is intellectual property now.
Yeah.
You can't put your fingers on it. It exists somewhere in the ether world. I guess this is going to be a bigger deal as time passes.
Yeah, I think so. And I think of course the other side of this coin is, what if the licensee goes into bankruptcy? The licensee. So we've been talking about the licensor in bankruptcy.
Good point. What about that?
Well, that's a different.
Well, let me ask you this. Let me ask you this. Let's think of I'm going to call it the worst possible license.
Okay.
Where the license says that the licensee cannot I should say assign, because you IP lawyers, you don't sell anything, you assign it. It says you cannot assign anything without the express consent of the licensor, which the licensor can give or not give depending upon how they feel about it. No discretion, absolute discretion. Yeah. So you're in bankruptcy. Mm-hmm. The licensee wants to sell it, and the licensor says no, period, end stop. But it's bankruptcy court. You can assign leases that the lessor doesn't want to allow you to assign. So let's do the same thing with respect to IP.
Yes.
What about it?
So
do I get away with it or not?
Seems like a great idea, except for another subsection of Section 365 of the Bankruptcy Code. And as a bankruptcy lawyer who deals with a lot of IP issues, this is something that I've certainly encountered. So the scenario that you've described is one, where there is someone else owns the intellectual property, and they're just the licensee of that intellectual property, but maybe they've built a business around that intellectual property, just like the licensees that Section 365N was designed to protect. But the Bankruptcy Code, Section 365C1, C as in Charlie, has a provision that essentially says that you can't assume or assign a license that involves intellectual property. It's a general section about executory contracts where applicable non-bankruptcy law restricts assignment or restricts the ability to be forced to deal with someone else. Personal services contract is another example, but with licenses, the intellectual property law that, say, governs patent licenses, copyright licenses, probably trademark licenses, says that those licenses are personal, that the identity of that licensee matters. And therefore, you need to get the consent, either in the agreement, not the agreement you described, the licensor wouldn't give it in that agreement, or you need to get a fresh consent, or you can't assign it. And some circuits, there's a bit of a split on this, some circuits say you can't even assume it. Even though you're the same licensee, because you're now in bankruptcy, the way they interpret that section 365C1, they interpret it as a hypothetical question. You can't assume or assign it. And the other circuits look at it as an actual test, which is, well, what are you doing? And so there's a risk. The bottom line is there is a risk in the scenario you describe where the licensee can't even keep their own license and they can't assign it, again, without consent. And so the most important section of a license agreement when the licensee is in bankruptcy isn't the bankruptcy section that probably says, oh, well, it can be terminated if you file bankruptcy. Well, that's an ipso facto clause. That's not going to be enforced. It's the assignment section.
Oh, goodness. I love it. You know, this just shows you how extremely difficult IP is by itself. And then when you overlay bankruptcy, it makes you want to go screaming off into the hallway. I mean, I sympathize with you for having to deal with this all the time, but thank you for what you have told us. This has really been an enlightening discussion for me, and I appreciate it. Intellectual property, as we see now, is a tricky area in any situation, and in bankruptcy, it's just beyond understanding. And I'm glad to have somebody like you who can help us to understand it. So we thank you for your insights. And we thank our audience for tuning in. The Industry Viewpoints series in the upcoming days and weeks, we will be talking with other experts in other areas about the future of industries that are being affected by our turbulent economic times. But until then, be well, stay safe, and we'll see you soon. Good day.